George, go ahead. You're on WDBO.
Well, thanks for taking my call. My wife and I have a family trust, and when we both pass away, the half will go to my son and half will go to my daughter. My son is married, but he has no children. My daughter has married and has 3 children.
Okay.
When my son and daughter get that money, is there a way to keep it separate so that when they pass away, I want that money to go to my grandchildren?
So, George, first of all, Florida law is very clear that what your children inherit from you is theirs to keep if they get divorced, with this one qualification. When they inherit assets from you, whether it's cash or whether it's a piece of real estate, they need to keep that asset in their individual name. If they do so, they get divorced, then they're going to leave with it. If they take that asset that they got from you, whether it's cash or a piece of real estate, and they put it in a joint account with their spouse or add their spouse's name to the deed, they get divorced and that spouse is going to leave with one half. Now, George, if this is that important to you, then you may want to consider going ahead and including your grandchildren as part of your estate plan so that when you and your wife pass away, it does not all go to your 2 children. Some of it's going to your grandchildren and being when you pass away. That way you could make sure it gets done. What do you think, Chrissy?
Yes, and so I think it would be reviewing his trust and helping him come up with a plan that is going to be best for your family, including, George, your grandkids.
George, does that answer your question, George?
Yes, it does. Would you have to start a whole new trust, or would you add a codicil or something like that? How do you do that?
So trust, George, when there is a trust and we need to make changes to that trust, we do that using a trust amendment. So no, we are not throwing out your old trust. We're simply amending what you have.
Okay, now I'm in Cocoa Beach. If I wanted, could you do this for me? We're old. I'm 88. My wife's 85. We don't drive much anymore. Is there a way to do this that we could mail it to you and we could do this thing?
Absolutely, George. We would be pleased to help you here at the Olsen Law Group in Orlando. And again, folks, we offer a free review of your existing will or trust. So, George, call us next week. Let's just figure out how we're going to get a copy of your trust and everything else we can do over the phone, George. We are pleased to assist you and look forward to being of service to you, George. That's the Olsen Law Group in Orlando.
At 407-423-5561. Give us a call, George, and we can absolutely help you with getting a copy to us. And we can do everything by phone and mail.
Thank you for calling, George. We appreciate it.